Another most important topic of public administration is privileges of administration. So these privileges of administration means privilege to withhold documents as a common law principle, and it is otherwise known as Crown's privilege. Simply speaking, it is a claim made by the state or the administration not to disclose certain facts in any suit or proceeding against it. The concept of Crown's privilege is based on the well known maxim solus populi est Suprema lex, which means public welfare is the highest law. So, in the leading case, Duncan versus Cammell Laird and Company Limited in 1944, it was held that documents should be withheld for public interest. So also in another leading case, and that is Billstone versus Stone, Professor Pollock said that if the proceeding of a state paper would be injurious to the public service, the general public interest must be considered paramount to the individual interest of a suitor in a court of justice. So, in view of that, the Crown Proceedings Act 1947 was enacted, and Crown and its servants and the government became liable for any action committed in regards to tort or contract. And in Burma Oil Company versus Bank of England in 1980, it was held in deciding the very question as to immunity, the relevancy and the cognancy of the evidence, along with other matters, may also be kept in balance. And so also in another leading case, Air Canada versus Secretary of State for Trade 1983, so also in Science Research Council versus Nashi in 1980, confidentiality and public interest came in conflict with interest of justice to the litigant. So also now we'll go to the very position of privileges as we found in United States of America, as the American democratic system is having a written and federal constitution, so they have an open government. So in the United States and Reynolds in 1953, it was held that determination of privilege and the immunity of withholding of documents even where the state secrets are involved to be a judicial function. So, in New York Times Company versus United States in 1971, Justice Douglas observes secrecy is anti-democratic, perpetuating bureaucratic errors. So, open discussion based on full information and debate are vital to the national health. So, also in Watergate Tape case in United States versus the former late President Richard Nixon in 1974, the court rejected the claim of withholding the tapes containing conversation between the President of America and his officials. So, in light of that, the Freedom of Information Act 1966 to be discussed, as it provided disclosure should be general rule. All have equal right of access. Burden of proof of withholding documents is on the government. And lastly, in case of denial of access to documents, an individual has a right to seek injunctive relief in the court. So every citizen is held to have a legally enforceable right of access to government files and documents. So now we'll go to the very position of administration's privilege in India. The constitution and law allow certain privileges to the government as a litigant. From among the numerous privileges available to the government under various statutes, the following are important one. So the first one, privilege of notice as provided under Section 80 Clause 1 of Civil Procedure Code 1908 provides that no suit will be instituted against the government or against a public official in respect of any act done in his official capacity until the expiration of 2 months next after notice in writing. So, in the manner provided, and also in the leading case, Swami Singhal versus Union of India in 1966, it was expressed that the requirement of notice is mandatory and admits of no exception in case of official has acted without jurisdiction. Notice is not mandatory. Seizure of property without authority or assaulting a witness. No notice is necessary. So the second principle that is found privilege to withhold documents as under Section 123 of Indian Evidence Act 1872, no one is permitted to give evidence from unpublished official records relating to the affairs of the state except with the permission. So also Section 24 provides the privilege to withhold documents as provided under Section 123, which extend also to confidential official communication. So also under Section 162 of the Evidence Act provides that when a witness is required to produce a document, he must bring it to the court and then may raise an objection to its production and admissibility. So, in state of Punjab versus Sodhi Sukhdev Singh in 1961, Chief Justice Gajendra Gadkar expressed the sole and the only test which should determine the decision of the head of the department is injury to public interest and nothing else. In this instance case, the Supreme Court laid down the following rules, and those are the claim of privilege should be in the form of an affidavit, and secondly, reasons for refusing disclosure must be cited. Thirdly, the court is empowered to summon the authority for cross examination in case of refusal. So, in the leading case, Indira Nehru Gandhi versus Rai Narain in 1975, the Supreme Court compelled the production of blue books of the police and disallowed the claims of privilege to the police officials. Also in R.K. Jain versus Union of India in 1993, Rule Nisi was issued to produce the file relating to the appointment of the President of the Central Excise Gold Appellate Tribunal. After inspecting the file, the apex court allowed the privilege claimed by the government. So, these are the privileges available to the administration in their functioning, and besides that, under what circumstances and under what extent the very privilege is available, and under what conditions such privileges could be refused, as it is discussed, as we found in different leading cases, as it was expressed by the apex court or Supreme Court, and so also in the very leading case where Justice Gajendra Gadkar, the then Chief Justice, he laid down certain rules, and those rules relating to the very privilege of the administration, and in the condition of refusing to disclose such documents as privileged documents, or regarding maintaining secrecy or confidentiality. So also the very argument for which the court is empowered, as expressed by Chief Justice Gajendra Gadkar, to summon the very authority who is refused to disclose such information as privileged information to be cross-examined in the court in case of refusal. And in that context, we have discussed the very important leading case, Indira Nehru Gandhi versus Rai Narain, a case of 1975, and that is regarding the production of the blue books of the police, which the police claims to be a privileged document, and how it was disallowed, the very claim of privilege, by the apex court. So also the very important leading case R.K. Jain versus Union of India of 1993, where exactly there is the application of Rule Nisi for the very production of the file relating to the appointment of the President of the Central Excise Gold Appellate Tribunal. So, in this connection regarding the privilege of administration, we have also discussed certain relevant sections of Indian Evidence Act of 1872. So, in our upcoming video, we'll discuss the very administrative functions of the administrative authority.